Hello students, let us further discuss on Companies Act 1956. In this session, I will explore allotment of shares, directors' appointment and companies' various types of meetings. This session must be very helpful to those who are establishing their own new company. It provides strong dialogue on company establishment and legal formalities for new entrepreneur. Let us now discuss about allotment of shares. When a company wishes to raise capital, it may do so by bringing a fresh issue of shares in the market. The people who wish to purchase the shares of the company can apply for the number of shares desired by them in an application form accompanied by some money called application money. After a specified time, the company issuing shares scrutinizes all the applications and allots the shares to the eligible applicants. What is allotment? The Companies Act 1956 does not define the term allotment. Allotment is governed by a number of general and special provisions. These are the first one, general provisions. As mentioned earlier, allotment leads to a contract between the company and the shareholder. Thus, some general provisions of Indian Contract Act 1872 apply to all allotment of shares. These are: first, proper authority. The allotment must be done by, that is, the board of directors or as mentioned by the articles. Second, reasonable time. The allotment must be done within or else the applicant may refuse to accept the offer. Communicated. The allotment must be a mere resolution is not enough. The decision to allot shares must be communicated to the shareholder. Absolute and unconditional. The allotment must be if the shareholder had mentioned any conditions in the application, the allotment is valid only if the conditions are met and not otherwise. If the above said provisions are not met, the allotment is null and void. The next is special provisions. As per the Companies Act 1956, there are certain conditions that must be satisfied for allotment of shares by a public company. These provisions differ depending on whether the issue is made to the public or not, and also whether the company is allotting the shares for the first time. First, allotment of shares. Initial allotment of shares can be done only if the company follows the following rules. First, registers its prospectus, that is section 60 subsection 1. The company has to file a copy of the prospectus duly signed by the directors with the registrar on or before the date when the prospectus is made available to the public. Next, receives the minimum subscription. Under section 69, a public company can allot shares only if it receives the minimum subscription for its shares along with the application money. The amount of minimum subscription is stated in the prospectus and cannot be less than 90% of the issue. If the company fails to receive the minimum subscription within 120 days of issue of the prospectus, then it will have to repay the money received from the applicants for shares within the next 10 days. If the company fails to do so, the directors of the company will be jointly and severally liable to repay the money with interest at 6% per annum after the said time limit. However, these provisions should be read in combination with SEBI guidelines. Next, receives application money under section 69. According to section 69 subsection 3, the amount of application money cannot be less than 5% of the face value of the share. Deposits the amount received in a separate account. According to section 69 subcross 4, the amount of application money received has to be deposited in a separate account in a scheduled bank till the company receives a certificate of commencement or till it raises the minimum subscription for the issue. Follows the rules regarding the subscription list, that is section 72. A company can only start allocating shares from the 5th day after the issue of prospectus or at a later time as prescribed in the prospectus. This time is known as the opening of the subscription list. According to section 74, while counting the 5th day, any day which is a public holiday under the Negotiable Instruments Act 1881 is not to be included. Although a default in following the provisions of section 72 does not invalidate allotment, but such a failure imposes on the company and every defaulting officer a fine extending up to Rs 50,000. The Companies Act 1956 does not specify the number of days for which the subscription list is to be kept open. But as per the norms of the stock exchanges, the list must remain open for a minimum of 3 days and should be closed within 10 days. Gets shares listed on a stock exchange, that is section 73. The company must apply to one or more recognized stock exchanges for listing its shares. The name of the stock exchange or exchanges where such permission is sought must be given in the prospectus. If the company fails to get the shares listed before the expiry of 10 weeks from the date of the closing of subscription list, the allotment is void. In such a case, the company has to refund without interest all money received from applicants within 8 days. If it fails to do so, the company and every defaulting director will be jointly and severally liable to pay back the money with interest at such a rate as may be prescribed. Above provisions apply. Thus, the company has to register its prospectus under section 60 subclause 1, receive application money section 69, follow rules regarding the subscription list section 72, get the shares listed on stock exchange section 73. It is, however, not required to ensure a minimum subscription and to deposit the money in a separate bank account. In case of allotment of debentures, the company is required to follow the following special provisions as explained. First, register its prospectus under section 60 subclause 1. Follow rules regarding the subscription list section 72. Get the debentures listed on a stock exchange section 73. Let us now discuss the rules to be observed for allotment of shares. The first one, a prospectus shall be filed with registrar. No allotment of shares shall be made to public unless the minimum subscription amount stated in the prospectus is raised and received by the company. Second, application for shares should be made in a prescribed form. Third, no allotment shall be made until the beginning of the 5th day after a date on which prospectus is issued. Next, companies intending to offer must make an application to one or more stock exchanges for permission. Next, the whole of the application money should have been paid and received by company in cash. Sixth, all monies received shall be deposited in a scheduled bank until the certificate to commence business is issued. The rights and duties of shareholders are defined from time to time of issue of shares. The rights of shareholders are fixed, which cannot be altered unless the Companies Act gets modified. Now let us discuss about Board of Directors. There are mainly two types of company directors: executive directors or whole-time directors, that is MD, technical directors, and non-executive or part-time directors who are professionals and serve on the board of many companies. Executive directors have employment stake in the company. They wield substantial power, enjoy maximum remuneration, perquisites, fees, commission and allowances. Part-time directors get only sitting fees for the board meetings attended by them and wield little or no powers. A director includes any person occupying the position of director by whatever name called under section 2 subclause 13. Only individual and not a body corporate, association or firm shall be appointed as director as stated under section 253. An individual who direct, control, manage, superintend the affairs of the company in the form of board of directors. Let us now discuss about shares. Share is defined as an interest having a money value and made up of diverse rights specified under the Articles of Association. Share capital, it means the capital raised by the company by issue of shares. A share is a share in the share capital of the company including the stock. Share gives a right to participate in the profits of the company or a share in the assets when the company is going to be wound up. Director elected by small shareholders according to section 151. Director elected by small shareholders according to section 151 of the Act states that every listed company may have one director elected by such small shareholders. For the purpose of this section, small shareholder means a shareholder holding shares of a nominal value of not more than 20,000 rupees or such other sum as may be prescribed. Rights of shareholders and members. Right issue which shareholders hold of a company under Companies Act 1956 are as follows. The first one, rights attached to shares of any class can be varied with the consent of shareholders holding not less than 75% of issued shares. Second, rights of dissenting shareholders. Protection by Companies Act is given to the shareholders who does not consent to or vote for variation of their rights. If there is any variation in any rights of any class of shareholders, then holders of not less than 10% of shares of that class can apply to the court to have the variation cancelled. It won't have any effect till it has been approved by the court. Third, voting rights of the members. Every member of a public company which have the shares holding equity have votes in proportions to his share in paid up equity capital. Next, preference shareholders don't have any voting rights. They can vote only on matters which are directly related to the rights attached to the preference share capital. There is a right to vote for every equity shareholder at general meeting. No company can stop any member from his voting right on any ground. The member's voting rights can be changed if member does not make payment or other sums which are due against. Next, let us discuss about appointment of director. The Companies Act 2013 does not contain an exhaustive definition of the term director. Section 2 subclause 34 of the Act prescribed that director means a director appointed to the board of a company. A director is a person appointed to perform the duties and functions of director of a company in accordance with the provisions of the Companies Act 2013. Minimum number of directors. Minimum or maximum number of directors in a company is prescribed under section 149 subclause 1. Section 149 subclause 1 of the Companies Act 2013 requires that every company shall have a minimum number of 3 directors in the case of public company, 2 directors in case of a private company, and at least 1 director in case of a one-person company. A company can appoint maximum 15 directors. A company may appoint more than 15 directors after passing a special resolution in general meeting and approval of central government is not required. A period of 1 year has been provided to enable the companies to comply with this requirement. Liability of an independent director under section 149 subclause 12. An independent director and a non-executive director except the promoter or key managerial personnel shall be held liable only in respect of such acts of omission or commission by a company which had occurred with his knowledge, attributable through board processes and with his consent or connivance, or where he had not acted diligently. The next topic to be discussed is company meetings. A company, being an artificial person, expresses its will or takes its decision through resolutions passed at regularly convened meeting of the general body of the shareholders and the directors. The Companies Act provides the shareholders a forum of self-protection, which is General Meeting of Shareholders. The shareholders can use the forum to appoint directors as well as auditors of their own choice who may safeguard them from the possible manipulation. The business of the meeting is conducted in the form of resolutions proposed and passed. Now, let us discuss about types of company meetings. First, shareholder meetings, statutory meeting under section 165, annual general meetings under section 166, extraordinary general meetings convened by directors on requisition under section 169. Types of other meetings are meetings of the board directors, meeting of the board committee, class meetings of shareholders, meetings of the debenture holders, meetings of the creditors, meetings of the contributors in winding up. Let us discuss about statutory meetings under section 165. Companies limited by guarantee and share shall within 1 month and not more than 6 months from the date of commencement of business hold a general meeting of the members to be called statutory meeting. Failure to hold statutory meeting renders the company liable to be wound up under section 433 clause B. This provision is not applicable to a private company under section 165 subclause 10. The board shall at least 21 days before the day on which the meeting is held forward a report to every member of the company called statutory report. Next, annual general meeting under section 166, 167 and 171. Every company shall in each year hold in addition to any other meeting an annual general meeting. Such meeting shall be specified in the notice calling it. Not more than 15 months shall elapse between the date of one general meeting and that of the next. The directors are responsible for calling a general meeting. A company may hold its first annual general meeting within 18 months from the date of its incorporation. Next, resolutions. Matters in a company are decided by resolutions in the meetings. Items listed in the agenda to the notice of the meetings are decided by resolutions. There are various kinds of resolutions. First, ordinary resolution. Second, special resolutions. Third, resolutions requiring special notice. Fourth, board resolutions. Now, let us discuss about minutes of the meeting. Every company shall keep the following books at the registered office of the company for purpose of recording the minutes. First, general meetings minute book. Second, board meetings minute book. Third, minutes of proceedings of committee of directors. There are now various kind of resolutions to be discussed. Resolutions mean decision taken at a meeting. A motion with or without amendments is put to vote at a meeting. Once the motion is passed, it becomes a resolution. A valid resolution can be passed at a properly convened meeting with the required quorum. There are broadly 3 types of resolutions. The first one, ordinary resolution. An ordinary resolution is one which can be passed by a simple majority. That is, if the votes including the casting vote, if any, of the chairman at a general meeting cast by members entitled to vote in its favor are more than the votes cast against it. The next thing to be discussed are special resolution. A special resolution is one in regard to which is passed by a 75% majority only. That is, the number of votes cast in favor of the resolution is at least 3 times the number of votes cast against it, either by a show of hands or on a poll in person or by proxy. The intention to propose a resolution as a special resolution must be specifically mentioned in the notice of the general meeting. Special resolutions are needed to decide on important matters of the company. Examples where special resolutions are required are let's say 1. To alter the domicile clause of the memorandum from one state to another, or to alter the objects clause of the memorandum. Second, to alter or change the name of the company with the approval of the central government. Next, to alter the articles of association. Fourth, to change the name of the company by omitting limited or private limited. The central government may allow a company with charitable objects to do so by special resolution under section 25 of the Companies Act 1956. Next, now let us discuss about resolution requiring special notice. There are certain matters specified in the Companies Act 1956 which may be discussed at a general meeting only if a special notice is given regarding the proposal to discuss these matters at a meeting. A special notice enables the members to be prepared on the matter to be discussed and gives them time to indicate their views on the resolution. In case special notice of resolution is required by Companies Act 1956 or by the articles of the company, the intention to propose such a resolution must be notified to the company at least 14 days before the meeting. The company must within 7 days before the meeting give the notice of the proposed resolution to its members. Notice of the resolution is required to be given in the same way in which notice of a meeting is given, or if that is not practicable, the company may give notice by advertisement in a newspaper having an appropriate circulation or in any other manner allowed by the articles not less 7 days before the meeting. The following matters requiring special notice before they are discussed before the meeting. First, to appoint at an annual general meeting appointing an auditor a person other than retiring auditor. Second, to resolve at an annual general meeting that a retiring auditor shall not be reappointed. Next, to remove a director before the expiry of his period of office. Next, to appoint another director in place of removed director. Fifth, where the articles of a company provide for the giving of a special notice for a resolution in respect of any specified matter or matters. Please note that a resolution requiring special notice may be passed either as an ordinary resolution, that is simple majority, or as a special resolution, that is 75% majority. Now let us discuss about circulation of members' resolution. Generally, the board of directors prepare the agenda of the meeting to be sent to all the members of the meeting. A member by himself has very little say in deciding the agenda. However, there are provisions in the Companies Act which enable members to introduce motions at a meeting and give prior notice of their intention to do so to all other members of the company. If members having 1/20th of the total voting rights of all members having the right to vote on a resolution, or if 100 members having the right to vote and holding paid up capital of rupees 1 lakh or more require the company to do so, the company must give to the members entitled to receive notice of the next annual general meeting notice of any resolution which may be properly moved and is intended to be moved at that meeting, and circulate to members entitled to have notice of any general meeting sent to them. Any statement of not more than 1000 words with respect to the matter referred to in any proposed resolution or any business to be dealt with at that meeting. The expenses for this purpose must be borne by the requisitionist and must be tendered to the company. The requisition signed by all the requisitionists must be deposited at the registered office of the company at least 6 weeks before the meeting in case of resolution, and not less than 2 weeks before the meeting in case of any other requisition, together with a reasonable sum to meet the expenses. However, where a copy of the requisition requiring notice of resolution has been deposited at the registered office of the company and an annual general meeting is called for a date 6 weeks or less after the requisition is deposited. The copy, though not deposited within the prescribed time, is deemed to have been properly deposited. The company is required to serve the notice of resolution and or the statement to the members as far as possible in the manner and so far as practicable at the same time as the notice of meeting, otherwise as soon as practicable thereafter. However, a company need not circulate a statement if the court on the application either of the company or any other aggrieved person is satisfied that the rights so conferred are being abused to secure needless publicity or for defamatory purposes. Secondly, a banking company need not circulate such statement if in the opinion of its board of directors the circulation will injure the interest of the company. Okay friends, let us summarize today's session. In this session, we covered legal process related to establishment of companies. This lesson delivers how allotment of shares, members and companies meetings are contributing their own role for the success of company. Resolution given the whole idea of how it's required for special concern in Companies Act and given complete specifics for resolution which is significant to the companies while transiting resolution. I hope this lecture must be very helpful to the students and those who want to start their own company. Thank you.